Judge. It does with the motion to exclude, in fact, Mr. Calvin is still in the.
Your Honor, may I be heard on this issue?
What else is there to hear?
Well, Mr. Calvin is a reporter who's covering this trial. He's being excluded from the entirety of the trial. We've had
No, that's inaccurate. He's not excluded for the entirety of the trial. And I made myself perfectly clear, I believe, that he's excluded until we address the issue of the motion to quash the subpoena. And it'll be after the state's witnesses that Mr. McKay mentioned, the Torres, I can't remember the name, Torres.
Well, he's here as a reporter to cover this trial. And that order excludes him then from doing
Correct.
the First Amendment right to do that. We understand if you want to exclude him while the Torres testified, but other than that, I don't see any justification for keeping him out of the trial when he is only going to be here, if at all, on an extremely narrow issue that could be narrowly tailored. And no, excluding him entirely is excluding a member of the media from covering a public trial with no justification that I have seen as to why he needs to be excluded other than for that very little time.
Anything further?
No.
Your objections noted but overruled. State?
Judge, because this is a bench trial, we have elected to keep our opening statement brief.
You can keep it however, whatever length you choose.
This case is about violating the public trust. The case is clear, the case is straightforward, and it's concise. It boils down to what defendants wrote on paper versus what is shown on video. The evidence will show that defendant March, defendant Gaffney, and defendant Walsh each knowingly filed false police reports, thereby committing the act of official misconduct and obstruction of justice, and that they participated in a conspiracy to commit those same crimes. So what did they do? The evidence will show that on October 20th, 2014, defendant Gaffney and his partner, Officer Joseph McGilligan, were on duty in the 8th District. They received a call through dispatch that indicated that there was a man holding a citizen, a male who he caught breaking into trucks and stealing radios, and that this was occurring near 41st and Kildare. Defendant Gaffney was driving the squad car at the time, and so they drove over to that location. When they got there, there was a man who said to them that the person they were looking for had walked off toward 40th Street. So defendant Gaffney and Officer McGilligan drove that short distance and quickly encountered a young man who was walking toward Keeler. The young man actually tried to hide in the bushes, but they saw him. And so Officer McGilligan, who was the passenger in the car, got out of the car, walked over to the young man and said, "Hey, turn around, show me your hands." The young man, who we now know is Laquan McDonald, was a 17-year-old African-American teenager who was wearing a hoodie and some jeans and had kept both of his hands in his pockets. And then he took his right hand out of his pocket and showed Officer McGilligan the knife. Officer McGilligan then said to his partner, defendant Gaffney, "He's got a knife." Officer McGilligan then drew his gun. Defendant Gaffney then called police dispatch and reported that there was this offender who was walking away from them who had a knife. Police dispatch then requested a vehicle with a taser to head over to that scene. McDonald, however, ignored Officer McGilligan as McGilligan continued to say to him, "Drop the knife, show me your hands, stay still, come here." McDonald continued to walk away. McGilligan continued to walk behind him. He stayed between 10 and 15 feet behind McDonald, which he thought was a safe distance. Defendant Gaffney continued to drive the car alongside as they walked. As McDonald got to the intersection near Karloff, which was approaching Pulaski, defendant Gaffney veered his car in front of McDonald in order to stop him from moving east. McDonald stumbles and he pops the tire with his knife. Defendant Gaffney could still hear the air hissing from the tire, but the car was still moving. So he continued and again moved the car in front of McDonald, attempting to stop him from moving east. McDonald then scratches the window of the car with his knife, but he then continues to go in his direction and to ignore Officer McGilligan and Defendant Gaffney. Officer McGilligan then puts his gun back into his holster and he starts to chase after McDonald. McDonald then goes through a parking lot near a Burger King that was nearby. At this stage, Defendant Gaffney and Officer McGilligan are engaging in what could be called good police work. They're following the potential subject. They're trying to engage him. They're keeping a safe distance. They're using time. They're waiting for the taser. They're assessing and reassessing the situation as it unfolds. McDonald at that point is a suspect who has a knife, who potentially committed nonviolent crimes, breaking into trucks, stealing radios, popping a tire, scratching a window. Defendant Gaffney continued to keep dispatch up to date on what was taking place. They followed him for almost a quarter of a mile. They went past industrial buildings. They went past the intersection of Keeler and 40th Street. They went past the Greater Chicago Food Depository. They went past the intersection of 40th and Carlisle. And finally, they get through this parking lot at Pulaski. Officer McGilligan would testify, Judge, that during this entire time, he never felt that McDonald threatened the use of deadly force. You'll also hear that there was testimony that Gaffney has testified that he did not feel at risk of death or serious bodily injury.
The objection noted, no rule.
Even though McDonald popped the tire and scratched the windshield of the car. As they neared Pulaski, squad cars began to arrive from other directions. So you've got lights flashing, sirens going. One car contained two officers, Viramontes and Dorfontaine. She can see Laquan McDonald as he's walking down Pulaski. But Officer McGilligan and Defendant Gaffney have lost sight of him at that point. They hear shots. They arrive at the scene at 41st and Pulaski. Laquan McDonald is on the ground. When Officer Viramontes and Fontaine arrive, she sees Laquan McDonald turn and fall to the ground. She gets out of her car, comes around the front of the car, as Officer Jason Van Dyke is shooting Laquan McDonald for the last of 16 times. She indicates, and will indicate to the court, that she saw this black male walk down the middle of the street and cross over the yellow line. She saw him swing a knife. She saw him turn and fall to the ground as her car approached, but she didn't know why he was turning. She didn't know why he was falling until after getting out of her car and realizing that he was being shot. She could hear drop the knife. She could hear the bullets. She saw him twitching. She saw the smoke come from his body. What she did not know, and will testify to, is that she did not see McDonald attack or attempt to attack anyone before or during the shooting. She did not see him swing the knife in an aggressive, exaggerated manner toward anyone. She did not see him continue to advance toward Van Dyke, nor did she see him raise his arm toward Van Dyke as if attacking Van Dyke. She did not see him raise knife across his chest over his shoulder. She did not see McDonald point the knife at Van Dyke. She did not see him attempt to get up while he was being shot by Van Dyke. She did not see him batter anyone. Yet the evidence will show that official police reports completed by Defendant March and others contain those false statements. A video will show that McDonald walked southwest across the double yellow line, across a full southbound lane on Pulaski. And the video will show that when they got out of the car, Defendant Walsh did not back up, but instead advanced toward McDonald. Van Dyke did not backpedal and fire, but instead took 6 steps toward McDonald and fired his gun 16 times. But the official police reports contained those false accounts that defendant Walsh backed up and Van Dyke backpedaled and fired, as the evidence will show. The evidence will further show that there are laws, general orders, police policies, and procedures that govern police officer conduct. The laws and general orders require justification in order to use deadly force. Immediately after the shooting of Laquan McDonald, the issue of justification became important. Those who are sworn to tell the truth began to fashion a story, to shape a narrative, to provide false information and create the lies that were designed to help Van Dyke avoid the consequences of his actions, to help Van Dyke avoid the punishment that might come with using deadly force without justification. Instead of protecting the scene, gathering names of witnesses, trying to find out who had a clear view of the incident, as required in general orders, the evidence will show that 2 citizens who were in their vehicle within yards of the shooting were shooed away by the officers who failed to ask them for any contact information, to give them contact information, or to even ask a single question about whether they saw what had happened. They gathered dash cam video and they viewed it at the Dunkin' Donuts, which was across the street. Officers Fontaine and Viramonte were put in charge of collecting preliminary information for the case incident report. Officer Fontaine will testify that that all of the substantive information that she put in her reports was given to her by Defendant March. Defendant March told her to list the defendants, Walsh and Gaffney and Van Dyke, as victims of an aggravated assault by McDonald, stating that Van Dyke had been injured by offender. The evidence will show that witness officers at the scene that night were directed to the area headquarters to be interviewed by Defendant March. But before their official interviews, they got together. Defendant Walsh and Van Dyke and detectives looked at video together and commented on what they saw or what they wanted it to show. Defendant March then interviewed officers who were on the scene and again, did not take contemporaneous notes, did not confirm that his understanding of the statements was correct, did not show the officers notes so that he could check those for accuracy, did not offer to allow the officers to review the reports to make sure that the statements he claimed he got from them were accurate. The evidence will show that ultimately Defendant March wrote police reports and included information that was false, including one statement that is false beyond any reasonable doubt. That statement was that the recovered in-car camera video from beats 845R and 813R was viewed and found to be consistent with the accounts of all witnesses. In fact, Judge, the evidence will show that the video from 813R directly contradicts the accounts of many witnesses as described by March. Defendant March's false statement is compounded by his complete failure to note where the video directly contradicts the statements given to him by witnesses, including Defendant Walsh and Jason Van Dyke. The evidence will show, Judge, that defendants Gaffney and Walsh, as well as Van Dyke, also completed and filed within minutes of each other tactical response reports, you'll hear the term TRR, and officer battery reports, you'll hear the term OBR. And those reports contain identical information that they knew was false. For instance, that McDonald had not fled, that McDonald attempted to stab or cut 3 officers, that the 3 officers were battered, that the 3 officers were an imminent threat of battery, that McDonald had attacked the officers with a weapon, and more significantly, that McDonald had used force likely to cause death or great bodily harm with a weapon, all to justify Van Dyke's shooting and killing of McDonald. There will be testimony that when Officer Fontaine found out months later that defendant March's reports included a false statement attributed to her, she was furious. She immediately contacted her lawyer. She wanted to set the record straight. But her reward for telling the truth was to be called a rat and to be told that she would not be safe on street duty. These simple, yet very important acts, lying on official police reports, are the crux of this case. Official misconduct, obstruction of justice, conspiracy to commit those acts. The evidence in this case will be clear. Defendants March, Walsh, and Gaffney each knowingly gave false information with the intent to obstruct the potential prosecution and punishment of fellow officer Van Dyke, and intentionally and knowingly provided false information in direct contravention to their duties and obligations under the law as public servants. And they conspired with others known and unknown to do so. Instead of serving and protecting all citizens of Chicago, the defendants tried to protect only one, Jason Van Dyke, by trying to create a false justification for the shooting of Laquan McDonald by Jason Van Dyke. Following presentation of the evidence, we will ask the court to find each defendant guilty beyond a reasonable doubt of the charges of conspiracy, obstruction of justice, and official misconduct. Thank you.
Thank you. Mr. McKay?